Google class. Dear students, today I am going to discuss with Transfer of Property Act. 1. Legal maxim. Nemo dat quod non habet. Nemo nemo dat dat quod 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 non non habet habet. Okay, habet. Okay, this legal maxim explain section 35, section 41 and section 43, okay, of Transfer of Property Act. Because this is a famous case, this legal maxim is applied these above sections 35 also mentioned, 41 also and 43. So here the nemo dat quod non habet means no one can pass a better title than what he has. This is the meaning. This maxim is explained in section 27 of the Sale of Goods Act 1930. Okay. An example where the goods sold by the finder. Okay. Who is a finder? Finder or thief. The buyer could not get the title. If any one of the thief get good title, or any one of the finder, for example, I lost my watch, something like, okay, if any one of the person find my watch, he is a owner? No, nothing. So where the goods sold by a finder or a thief, the buyer could not get the title. Okay. And second thing, where a person obtained goods under a hire purchase agreement and sold them, the buyer could not get the title. At that point, where the person obtained goods on approval basis, okay, the person obtained goods on approval basis and sold them, the buyer could not get title. So the same principle applied to the transfer of immovable property also, because these are all above explained in section 27 of the Sale of Goods Act 1930. But now the same principle also applied the transfer of immovable property also. So the transferor should possess a good title. Transferor means seller. Okay. So giver, seller or giver. So then only he could transfer the property. The right to property includes the right to transfer the property. Okay. Transferability is a general rule. Okay. And exception also available. Exception to the rule of nemo dot quod non habet. Okay. What are the exceptions? Section 41, section 43 and section 35. Section 41 says the doctrine of holding out. We already discussed earlier videos also. Doctrine of holding out. Okay, that means the ostensible owners gets a good title. Ostensible means he is not a original owner, acting owner, like benami. Okay. If the purchaser purchases the property from ostensible owner in good faith and for consideration also, he gets good title on the property against the real owner. Okay. This is called ostensible owner, explained in section 41 of the TP Act. And second exception of this rule, the doctrine of feeding the grant by estoppel. Section 43 explains this doctrine. If a man who has no title whatever to the property grants it by conveyance, which in form would carry the legal estate, and he subsequently acquires an interest sufficient to satisfy the grant, the estate instantly passes to the transferee. Okay. And third one, section 35 explain doctrine of election. What is that? Section 35 explains it provides a person acquires a better title from the transferor when he can invoke the doctrine of election against the true owner of property. Okay. That's all. 3 exception is available for the legal maxim nemo dat quod non habet. That's all. Okay. Okay, student. Read properly. Study properly. Okay. Be prepared in your examinations. don't stress about your in your legal subject also. Be alert. Okay, be happy. Thank you. All the best. Take care.